Vice President.
Hello, everybody. A very good evening to you, ladies and gentlemen. I warmly welcome each and every one of you to the 24th webinar of the continuous weekly webinar series organized by the Bar Association of Sri Lanka. I take this opportunity to extend my gratitude as well as your gratitude to the Bar Association of Sri Lanka for providing continuous professional development free of charge to all its viewers. It's a pleasure to note that this webinar series has reached out to members from the North, the South, the East, and the West, covering our membership and all others who are interested as well in Sri Lanka, as well as the members from different parts of the world. So none of this would have been possible if not for the efforts of those who are working behind the screen, even right now. Today being the birthday of Mr. Saranga Hettiarachchi, who heads the IT support team of the BASL. We want to wish him a very happy birthday and all the very best, and thank him for assisting with the technical support from the inception of this series. Right, so moving on. Today we discuss an area which was, is, and will always be important to us. Not only as members of the legal fraternity, but also as human beings who depend upon Mother Nature. So the topic for today's webinar is environmental laws. It's time to act now or never. As Dalai Lama said, it's our collective and individual responsibility to preserve and tend to the world in which we all live in. Because the fact of the matter is, unless we sustain our environment, we cannot sustain ourselves. This is why we, as members of the legal fraternity, need to be updated with the laws, the regulations, methods of implementation, and actions pertaining to environmental law. So to speak to you on environmental law and the subtopic, it's time to act now or never, we have a fabulous panel of experts who are well versed in the field and carry valuable experience. So let me take this opportunity to introduce to you the esteemed panelists of this evening. I'm pleased to have with us Mr. Ravi Agama, attorney at law, who has practiced for over 38 years as a counsel in civil and labor cases and as an arbitrator. He co-founded Environmental Foundation Limited in 1981 as Sri Lanka's first public interest law organization on environment and has held several posts, including the post of chairman. He has been involved in many environmental activities and was a member of the Presidential Task Force on Wildlife Conservation in 2000-2001, a member of the Fauna and Flora Advisory Committee from 1990 to 1996, a member of the National Marine and Biosphere Committee UNESCO of the National Science Foundation 2006 to 2020, a member of the Steering Committee Forestry Resources Management Project, member of the Steering Committee Protected Areas Conservation Project, chairman of the Environment Committee of the Bar Association of Sri Lanka, faculty member of the Institute of Human Rights, member and former editor of the Sri Lanka Natural History Society, trustee of the Young Zoologists Association of Sri Lanka, director representing South Asia of Environment Liaison Center International, Nairobi, Kenya, 1988 to 1990, chairman of the Sri Lanka National Committee of IUCN, the World Conservation Union 2002 to 2004, chair of the Asia Committee of IUCN, the World Conservation Union in December 2003 and 2004. He is also a visiting lecturer in environmental law at the University of Colombo, University of Sabaragamuwa, and the Open University. Welcome aboard, sir. We also are honored to have with us Mr. Jagat Gunawardana, attorney at law. He is a veteran environmental activist who has been a defender of our forests, flora, and fauna, representing civil society to fight environmental destruction for more than 4 decades. He has spearheaded numerous campaigns against deforestation, poaching, illegal sand mining, and many other environmental and wildlife issues. He is presently a lecturer on environmental law at the University of Colombo, a member of the Environmental Foundation Limited, He has also served as the chairman of the Environmental Council. Out of the several awards he has received in recognition of his services to the environment, it is worth mentioning that Mr. Gunawardena is a recipient of the Presidential Award for Outstanding Work Done for the Environment in 2005, the Lifetime Achievement Award Haritabhimani for the service done for wildlife conservation in 2016, and the Presidential Award for Outstanding Work Done for Wildlife in 2017. I would also like to welcome and introduce Mr. Ravindranath Dabre, attorney at law. He holds a high national diploma in engineering from University of Moderator. He has over 23 years of practice. His area of practice includes civil law, administrative law, and public law. Mr. Dabre is a prominent figure in public interest litigation and environmental law in Sri Lanka and has contributed in formulating many policies and regulations, including National Wetland Policy, genetically modified food import regulations, visual pollution control regulations, and the National Gazette containing environmental regulations through litigation. Mr. Dabre has published books titled Environmental Law and a Handbook on Environmental Law. I also take pleasure in introducing to you Dr. Kokila Konasinghe, attorney at law. Dr. Kokila Konasinghe received her LLB from the University of Colombo and LLM from Erasmus University, Rotterdam, and a PhD from Kiel University, UK. Dr. Kokila Konasinghe is a senior lecturer at the University of Colombo, where she currently teaches human rights law and environmental law. Dr. Konasinghe is the founding director of Center for Environmental Law and Policy at the University of Colombo. She is also currently involved in 2 SAARC regional level projects representing Sri Lanka. She is the former director of the Council of the University of Colombo. She was a visiting researcher and a teaching fellow at Erasmus University Rotterdam in Netherlands, University of Granada, Spain, and Jindal Global University, India. She collaborates many research programs with the Special Center for Disaster Research at Jawaharlal Nehru University in India. Her research interests are the North-South dimension in environmental governance, disaster management laws, role of NGOs in environmental governance, third world approach in sustainable development, and climate change laws. Her book chapters and research articles have appeared in locally and internationally reputed journals and publications. And now we move on to the moderator of the day. We have with us Mr. Vishwa Dilivera Tennakon, attorney at law. Mr. Vishwa Dilivera Tennakon, attorney at law, is a practitioner in Halsdorf, both in original and appellate courts. He served as the Assistant Secretary of the Bar Association of Sri Lanka from 2019 to 2020. He was the editor-in-chief of the Junior Bar Law Journal in the year 2013, and is presently the editor of the Halsdorf Law Journal of the Colombo Law Society. He functioned as the secretary of the National Law Conference in 2020. Mr. Tennakon is involved with public interest litigation in Sri Lanka. He has a Bachelor of Laws degree from the University of London and a Master of Laws degree from the University of Colombo, focused on environmental law, constitutional law, and criminal justice. So that will be your panel of experts this evening. Once again, I would like to extend a very warm welcome to all our esteemed panelists and the members of the audience who are joining this webinar on environmental law under the theme, It's Time to Act Now or Never. Without further ado, we move on with the session. I now hand over to Mr. Vishwa Dilivera Tennakon, the moderator of the day. I hope all of you have an interesting one. Over to you, Vishwa.
Thank you very much, Umayangi. A warm welcome to all of you joining us today. I thank the Bar Association of Sri Lanka for having organized this very necessary webinar at a very crucial time. I'm grateful to the panelists who have been invited today, who accepted the invitation today to speak to you all about these pressing issues. Modern environmental law is a relatively young branch of international law, which is developed in response to a mounting concern for the state of the global environment. From its inception in the 1970s, globally, its focus has arrested key concerns relating to the global environment. Yet the implementation of environmental policies have not been effective owing to the transboundary nature of its issues and the concept of national sovereignty. At the national level, us Sri Lankans can boast of a commendable history, one which thrived on coexistence amongst all sentient beings. In the case of Hungary versus Slovakia before the International Court of Justice, the Vice President of the court, Justice C.G. Veeramantri, referred at length to ancient irrigation works of Sri Lanka, which he said embodied the concept of development par excellence. He said, just as development was the aim of this system, it was accompanied by a systematic philosophy of conservation dating back to at least the 3rd century BC. The ancient chronicles record that when King Devanam was on a hunting trip, Arhat Mahinda, son of Emperor Asok of India, preached to him a sermon which converted the king. A part of that sermon was, "O great king, the birds of the air and the beasts have as equal right to live and move about in any part of this land as thou. The land belongs to the people and all living beings. Thou art only the guardian of it." During colonial rule, our fauna and flora suffered immensely due to the introduction of cash crops and activities such as trophy hunting. Even after the end of the colonial rule, some of our citizens and rulers seem to be blissfully ignorant of the finite character of the environmental resources and continue to obliterate our forests and kill its biodiversity. From an environmental perspective, Sri Lanka has a plethora of issues which needs to be addressed immediately. Deforestation, illegal sand mining, marine pollution, the killing of wildlife, waste management issues, invasive species, mangrove destruction, the human-elephant conflict, overfishing, air pollution issues are just a few to name. Unfortunately, through this webinar, we are not able to have an in-depth discussion of these issues. Today, we will focus mainly on a few of the major issues faced by the environment. I take great pride in inviting Dr. Kokila Konasingham, who I had the privilege of being lectured by at the University of Colombo, to give an overview of some of these burning issues. Over to you, madam.
Thank you, Vishwa. Aibowan. Good evening, everyone. I am truly happy to join you today on this BASL webinar series, because today it is on environmental law and that is my passion. So I like the organizers' approach to this area of law with this caption, that is, it's environmental laws, it's time to act now or never. Now, this caption reminds me of one of the famous captions by Rachel Carson. She is a world-famous environmentalist who published Silent Spring in 1962, after which the whole world began to reassess their approach to environmental laws and policies. Let me quote, "We can now where two roads diverge. But unlike the roads in the Robert Frost famous poem, they are not equally fair. The road we have long been traveling is deceptively easy, a superhighway on which we progress with great speed. But at the end of this lies disaster. The other fork of the road, the one less traveled by, offers our only chance to reach a destination that assures the preservation of our earth. The choice of, after all, is ours to make." So I think even this was written in 1962. I think it is highly relevant to the Sri Lankan case today. This leads us to evaluate the choices that we Sri Lankans, should make in this context. Therefore, it is time for all of us to act either now or never. One could question whether the environmental problems in Sri Lanka are that imminent, or whether the environmental problems in Sri Lanka are that crucial. I will not answer that question now. I will leave that to you to decide after all the panelists present their views on this matter today. I must also mention that environmental problems are transboundary. So you cannot define environmental problems territorially. So the legal remedies are also should be universal and transboundary. So it should take a holistic approach, reaching out the victims of environmental problems. Exploring the environmental problems in Sri Lanka today, I would like to focus two main issues. That is, out of many diverse issues, of course, that is forestry and wildlife. There are many common areas in both of these areas, deforestation and wildlife protection. Many reported and unreported recent incidents of killing leopards, elephants, and many wildlife species, and also Vilpattu, Singharaja, many debates are over the deforestation. So it will be very interesting to discuss about wildlife and forestry together. Mangrove destruction is another area that hugely debated recently, and it became a menace that is increasingly happening in many parts of the country. Another important matter related to marine life can also be highlighted here. That is species who are globally endangered, such as manta ray and eagle rays, nearly extinct in Sri Lanka. They are globally endangered, but unfortunately, they are not protected under Sri Lankan legal system. So Vishwa, these are some of the main areas, main significant environmental issues that I would like to focus on today's discussion.
Thank you, madam. Who better to address these concerns other than the champion of environment and animal conservation, veteran environmentalist, Mr. Jagat Gunawardena. Sir, what can we do?
Coming to the issue of wildlife conservation and forest conservation, I will put the two together and take them under the heading of biodiversity conservation and protection, because the term biodiversity means three things altogether. One is the diversity or the differences between the habitats. The second aspect is the diversity or the differences between the species of animals and the species of plants. And the third aspect is the difference within a species, or what we call the genetic diversity within a species. So taking the three aspects of biodiversity, forestry and wildlife can be taken under this particular heading of biodiversity conservation, and both forestry conservation and the habitat conservation aspect of wildlife is part of the conservation of biological diversity. Let me start off from there. One area of concern to us is the loss of habitats, as Dr. Kokila very clearly explained. And this is addressed by the law by making areas to be protected as protected areas. And under the Sri Lankan legal system, the predominant law that affords protection to the habitats is the Fauna and Flora Protection Ordinance, Under section 2, there are 3 basic types of protection to habitats. One is under the category of national reserves, the second is the sanctuaries, and the third is the managed elephant reserves. Unfortunately, there is no area that has yet been declared under the third category. So I will concentrate on the national reserves, which are of 7 types, and out of the 7, we have declared 5 types of protected areas, which are national reserves. And sanctuaries don't have subdivisions, and there are more than 80 sanctuaries all over the country. From the smallest sanctuary, which is the Ambalankoda Hikkadua Rocky Islet Sanctuary, which is 0.1 hectares in extent, although the beach area is several kilometers long from Ambalankoda to Hikkadua. And the largest is the Randanigala Rantambe Victoria Sanctuary, or the VRR Sanctuary, which is the largest one. And within the area, there are so many different sanctuaries, including 2 straddling the city of Colombo, the Sri Javardhanapura Kotta Sanctuary and the Belangila Attadiya Sanctuary. And under the Forest Conservation Ordinance, there are 2 types of forests that can be declared. One is called the conservation forest, and the other is the forest reserves or the reserved forest. In addition, there is a category called village forest. Unfortunately, the village forest only exists in the law. In the ground, they had been converted into cultivated lands and human habitations. In addition, the Forest Conservation Act, the Forest Conservation Ordinance has a very interesting fact when it comes to the protection of habitats. That is, any state land that is not declared under any other law is also automatically protected under the provisions of the Forest Conservation Ordinance, in particular under the provisions of Section 20. This is of very much importance in view of the impending government action in converting some of these lands, which they call the other state forests, into cultivations and human habitations and other industrial areas. Therefore, we have to see how the provisions of the Forest Conservation Ordinance had afforded protection to lands that had not been declared under any other law, but had been under a certain degree of protection. In addition, there is another piece of legislation that is almost forgotten, that is the National Heritage Wilderness Areas Act, under which habitats can be protected for 6 different reasons. But unfortunately, only the Singaraja forest had been protected under the National Heritage Wilderness Areas Act, and that was also in 1988. And since then, there had been no declaration. So these are the 3 acts or enactments that protect habitats of wildlife. When it comes to species, it is the Fauna and Flora Protection Ordinance that affords protection to species. And the 2009 amendment to the Fauna and Flora Protection Ordinance brought in a new degree of protection called strictly protected species for mammals, reptiles, and birds. And therefore, when it comes to mammals, reptiles, and birds, we have strictly protected species, we have protected species, and we have a small number of non-protected species. When it comes to the strictly protected category, Sri Lanka has 20 species of mammals which are strictly protected, 18 species of reptiles which are strictly protected, and 63 species of birds which are strictly protected. Coming to the strictly protected category of reptiles, I should add a word or two, because according to the list, there are only 16 species of strictly protected reptiles. Then how did the list grow into another 2? One is that the species known as the dwarf chameleon or the Cophatis phylonica was split into 2, with another species being found in the knuckles being named as a separate species. So because of the split, we presume that both of these have to be protected, because at the time the final amendment went into Parliament, there was only 1 species, and this was not a new discovery. But the most interesting or the important aspect is that under the protected category of reptiles, we had a genus totally protected, that is the genus Ceratophora or the horned lizards, which had 5 species at that time. And just a few weeks ago, another new species, the 6th species of Ceratophora, which is an endemic genus of lizards, had been discovered, which invariably makes it a strictly protected protected species by virtue of the fact that the whole genus is protected, and the number of strictly protected fishes, protected amphibians, and also protected invertebrates, as well as protected plants. Therefore, the Fauna and Flora Protection Ordinance is the predominant piece of legislation that affords protection to species of plants and animals. In addition, the Forest Conservation Ordinance also has Section 18, which affords protection to a list of species of plants. It's only plants that can be protected under Forest Conservation Ordinance. But there is another interesting piece of legislation when it comes to affording protection to species, that is the Fisheries and Aquatic Resources Act, under which we can give protection to species of aquatic animals and aquatic plants. Under Section 29, there are species of fish that had been protected, both marine and freshwater. And under Section 30, there are species of fish which are prohibited from being exported or regulated from being exported. So that's also a degree of protection that had been given under the Fisheries and Aquatic Resources Act. Let me come back to Dr. Kokila's other point on marine protection in the context of both the Fauna and Flora Protection Ordinance and the Fisheries and Aquatic Resources Act, because the Fisheries and Aquatic Resources Act can give protection to all marine species because they are deemed as fish under the provisions of the Section 66 of the Fisheries and Aquatic Resources Act, which gives the interpretation to include all aquatic animals are deemed to be fish for the purpose of the Fisheries and Aquatic Resources Act. Of course, it's not biologically correct, but it's a working definition. We don't have to worry about that. Coming to the aquatic animals, the Fauna and Flora Protection Ordinance has Section 30 up to Section 31B to give protection to different classes of marine species. But when it comes to fish, it is 31A that gives protection to fish, whether it's marine or freshwater. Then coming to the Fisheries and Aquatic Resources Act, it's Sections 29, and maybe if there is an export trade involved, Section 30 that can give protection to a species of marine fish. Coming to the issue of the species that she has mentioned, Sri Lanka has earned a very bad name because we have been deemed as a very perverse hunter of manta rays and eagle rays, because it's a very wasteful trade where only the gill rakers of the fish are dried and exported. The flesh is not exported. It's consumed sometimes locally, but sometimes because it's a large fish, a portion of the fish may be going waste, but it's a wasteful trade. And there is a restriction in many countries. And we had been clamoring that this has to be implemented in Sri Lanka because Sri Lanka has earned a bad name in the world arena because we have been loving the wanton killing of eagle rays and manta rays. In addition, I want to emphasize another species or category of species, the sawfishes. There are 5 species of sawfishes, of which I think there is a possibility of 4 species being found in Sri Lanka. I have not personally seen a sawfish being landed anywhere in Sri Lanka for a long time. And it is been told that the last reliable report of sawfish had been about 3 years ago. But anyway, they are on the verge of becoming extirpated in our waters, or maybe in a global scene also. They are the most endangered category of marine species, and we have nothing to lose by protecting them. Now the question is how to protect them. There are 2 ways. One is to protect them under Section 31A of the Fauna and Flora Protection Ordinance, and to protect them under the provisions of Section 29 of the Fisheries and Aquatic Resources Act. My personal opinion is that we can protect them under both, because there is no harm in giving dual protection to a species which needs the utmost protection that we can afford under the law. Coming to the Fauna and Flora Protection Ordinance, all offences are cognizable offences, and some offences, particularly the offences regarding the strictly protected species of mammals and strictly protected species of reptiles, are cognizable and non-bailable too. But when it comes to the Fisheries and Aquatic Resources Act, offences under Section 29 are not cognizable. So we can all see that the degree of protection that is given under the Fauna and Flora Protection Ordinance is higher when it comes to the punishments, when it comes to the other aspects of the law where we are interested with framing charges. The Fauna and Flora Protection Ordinance always can have much better provisions in framing charges than under the Fisheries and Aquatic Resources Act, but I always want them to be protected under both the laws. Coming to the issue of leopard protection, the leopard is again a strictly protected species of mammals under Section 30 of the Fauna and Flora Protection Ordinance, and killing or maiming or injuring or entrapping a leopard is a non-bailable offense and a cognizable offense too. Keeping part of a leopard under one's custody or possession also is a cognizable and non-bailable offense. So leopards are strictly protected. When it comes to elephants, elephants are strictly protected, not under Section 13, but elephants are protected by a series of provisions from Section 12 to Section 24 of the Fauna and Flora Protection Ordinance. Under Section 12, it's an offense to kill or injure or take any elephant illegally, and it also is a cognizable and non-bailable offense. So the law is there, and the mechanism is there under the Forest Department and the Wildlife Department. In addition, let me also point out a thing that has been mostly forgotten most of the time, that is the powers vested under the Fauna and Flora Protection Ordinance to the Wildlife Department can be exercised by the police as well as by the Forest Conservation Department. And the provisions under the Forest Conservation Department can be implemented not only by the Forest Conservation Department, but also by the police. So there is also a mechanism under the institutions to take care of the fauna and flora and the wildlife and the forest issues. But we will discuss later, if time permits, that is that these issues are still in the public domain because the implementation mechanism is rather poor, and the implementation is being hampered by different reasons. Thank you very much for affording me this opportunity. I just made a nutshell of the provisions plus the issues that were highlighted by Dr. Kokila. Thank you.
Thank you so much, sir. I think you have certainly used the very little window that was given to you and shared a wealth of information that I'm sure will be useful to a lot of the listeners and viewers out there. Dr. Konasinghe, ma'am, apart from the number of issues that you highlighted earlier, are there any other such significant environmental issues in the country that you would like to discuss? Madam?
Yes, Vishwa. Thank you. And also, I would like to mention that environmental problems can be dealt in many avenues of laws. Cases like Chunakam power plant case, Ippavala case, it went up to the Supreme Court and the Court of Appeal level. What many people are not aware of that, there are many legal remedies available at the original courts level. So many local environmental problems can be very effectively and efficiently dealt at this level. So actually, I would suggest magistrate courts, district courts, provincial high courts should be approached by the public for more efficient and more practical approach to environmental problems at the local level. And also, as you asked me that whether there are any other problems, the main problem that comes to my mind next is the waste management problem. Now, the waste management has also become one of the top environmental concerns in Sri Lanka today. With this regard, the role of local governments and the laws related to that, the municipal councils, urban councils, and Pradeshia Sabhas, particularly questionable. I suggest we should start looking at regulatory duties of these statutory bodies cautiously. So I think that is very interesting area to discuss next.
Thank you very much, madam. And it's very important to understand that the magnitude of environmental issues, because there are certain things that you can also do at your a local level on a personal basis rather than having to resort to a collective effort. And to address these concerns, I'm pleased to invite another individual who is at the very forefront of the war against the destruction of the environment, Mr. Ravindranath Dabare. Sir, over to you. Sir, the mic seems to be muted. Mr. Dabare. Hello, sir.
Thank you very much for affording me this opportunity to discuss the matters related to the waste issues and how environmental law could be practiced in local level, especially by the attorneys at law, without coming to the Supreme Court. Firstly, I would like to address the issues relating to the waste, because issues related to the waste is one of the biggest problems faced by our country these days. We have our own problems as a country in relation to matters relating to the disposing of our own waste. If we can, if you all can remember the Meetotamulla issue, actually the Meetotamulla wage mountain was collapsed, and as a result of that, number of human beings were dead, or we lost number of lives. That depicts and exhibits the nature of the issue of waste or waste issue that we have as a country. And after the Meetotamulla disaster, Center for Environmental Justice filed a fundamental right application in the Supreme Court. I was the counsel there. We sought a order from the court to formulate a national waste management policy applicable to the whole country, taking all relevant facts into consideration and practically implementable policy has to be formulated. The court accepted our application, and even the Ministry of Environment also accepted our application, and we filed the case in 2000 some years ago, but ultimately we were able to formulate the policy. Now policy is in the hands of the cabinet. Once the cabinet approval is granted, the policy will become a part of the regime of the environmental law. And in addition to our own environmental issues relating to waste, we have other external issues relating to waste. For example, in 2003, I can remember, we had to go to the court to repatriate 184 containers reached to Sri Lanka to dump chemical waste in Sri Lanka. And we were able to obtain court orders to repatriate 184 containers containing oxime carbamate imported from China. And even recently, you know, we had to go to the courts, and especially Hemantha Vitanage and Center for Environmental Justice went to the Court of Appeal and sought orders for the repatriation of 242 containers brought to Sri Lanka from UK. These contain UK hospital waste. Now you can understand the nature of the problem. And actually the one portion of the about 72 as I can remember, containers from the UK waste containers, they were repatriated yesterday, and according to the today's newspaper, I am glad to see that. But all these examples shows what the pressure from the developed countries we experience, especially when they are trying to dump their garbage also into our country. So we have to take this issue very seriously when such high level of concern is given both locally and internationally to the waste management area of this country. Now, especially when we consider the definition given in the National Environment Act for the waste, Section 33 of the National Environment Act actually defines waste. It includes liquid, solid, and gaseous and radioactive material which can cause alteration of the environment. Now, local waste management and punishment for the offenders are governed by a number of legal regimes. Those are National Environment Act, Penal Code, Criminal Procedure Code, Police Ordinance, Municipal Council Ordinance, Urban Council Ordinance, Pradeshiya Sabha Act, Nuisance Ordinance, Coast Conservation Act, BOI Act, etc. And international waste movement, such as waste import and export, is governed by the Basel Convention, which we have ratified as a country in 1992. If we look at the provisions in the National Environment Act in relation to the waste management, Section 10D, 10F, 10G, 10H, 10K, 16D, 23G, 23M, 23A, 23B, and especially 23H, which is dealing with the water pollution. The water pollution is very important. And under this section, there is a special provision that the polluter is liable to compensate the damage. That is, the polluter pay principle is included to this particular section. 23N deals with soil pollution. That is also important. According to the definition, or according to the description of the soil pollution, it says any soil or surface of any land you can't pollute. That means even the land belongs to you, you are not entitled to pollute it. Now, I can give you one such example. What happened in Ratupaswala case? Ratupaswala case, the factory owner dumped their own waste, actually liquid waste, to their land. Actually, it is their land, but through the sand, it reached the neighbors' water sources. Therefore, even in the Ratupaswala issue, we had to go to the court and obtain court orders to relocate the industry because according to the section 23N of the National Environment Act, you are not entitled to pollute any soil or surface of any land. And 23K of the National Environment Act deals with the pollution of atmosphere and under this section also, polluter pay principle is included. That means any party who polluted the atmosphere is liable to pay the damage, and even it may be that the damage may be incurred, maybe that may be actually by way of a fine, the court can impose to cover the damage. And even under 24A, there is a special provision when the environmental officers of the national under Central Environment Authority reaches the places, private places, they can accompany a police officer just to overcome other issues. Sometimes there may be a pressure from the owners, or sometimes there may be restrictions from the owners towards the officers of the Central Environment Authority. And especially under the National Environment Act, we have to discuss two important gazettes which deals with the waste. Those are 1533/16 and 1534/18. Those are very important gazettes issued under the National Environment Act to deal with the waste discharge. These gazettes actually deals with the amount of waste that could be discharged, maybe liquid waste, solid waste, or even these gases deal with the hazardous waste. What are the waste that cannot be added to the environment, and what are the waste that can be added, and what are the licenses required to be obtained by the party who transport, party who emit waste, and party who generates waste. All these things are specially stipulated in this particular gazette notification 1534/18. Those two gazette notifications were issued in 2008. And there is another important thing. There was a IGP circular issued. The circular number is 1155/94, 1154/94. Actually, this IGP circular deals with section 23A, 23H, and 23K and 23N of the National Environment Act, and empowers the police officers to deal with the violation of those sections. That means even the police officers can handle the issues coming under the section 23A, 23H, 23K and 23N of the National Environment Act according to this IGP circular. In addition to that, according to this IGP circular, there is a gazette notification issued by the under the National Environment Act, which is commonly known as 772/22. Under that, there are certain projects that requires EIA or IEA. And for such projects, if done without obtaining or without performing EIA and without abiding to the sections 23AA and 23EE, the police can take action. They are clay mining in river or stream beds without approval, and mining of any kind in river stream beds without approval, and rock quarries established after 24th June 1993 without approval, and service stations in residential areas without an environmental protection license, which is commonly known as EPA. And in addition to that, there are some other laws which deals with the environmental issues, especially the waste issues. As my topic is limited to the waste. If we get the penal code, which is very common to most of the attorneys at law, we can use the section 261, 263, 270, 271. All these sections are related to pollution and public nuisance. This involves actually issues relating to the waste. Even the police and police can go to the courts under this section. If the police is not prepared to go to the courts, even a private plane could be prepared by any private party through an attorney at law and go to the courts for remedial actions. Even the
Mr.
the
Tabari,
most,
you have 1 minute more, sir.
Pardon?
You have 1 minute more, sir.
Yeah.
Sorry to disturb you.
Actually, Vishwa says I have 1 minute more. And I can't actually, I will rush through the important, even the Criminal Procedure Code section 98, which is very important and widely used section to obtain conditional orders. Actually, even under this, even the police can file action when there is an issue, related to the waste or any environmental issue. That means most of the environmental issues, according to my view, can be coupled under the section 98, and even the police ordinance section 63, municipal council ordinance section 129, 130, 131, and from sections from 132 to 136b. Even the Urban Council Ordinance section 92, section 118, 119, and 120. Pradeshi Sabha Act section 93, 94, 95, and sections 100, from 100 to 107. Those things are actually dealing the issues related to the waste pollution, waste and the pollution. Even there is a special ordinance which deals with pollution and the waste, that is Nuisance Ordinance number 15 of 1862. And Coast Conservation Acts also, section 25 deals with the waste in the coastal zone, and the Director General of the Coast Conservation Department is duty bound to manage the waste in the coastal zone. And BOI Act is also important. Section 20A, subsection 2 deals with the issuing of license, especially license to discharge waste. And this has to be done in concurrently with the National Central Environmental Authority. And there are other type of pollutions, but not they are not related to waste. Other pollutions are sound pollutions, visual pollutions, but as my time is limited, I do not deal with these things. But Vishwa, can you give me 1 minute? And international
sure.
Waste management is governed by the BASL Convention. BASL Convention, actually the monitoring body of the BASL Convention of the of our country is the the Central Environment Authority. There is a special technical committee appointed to deal with that, and actually, without coming to the Supreme Court and the Court of Appeal, we can get use of the section 98 of the Criminal Procedure Code for most of the environmental issues, because section 98 deals with when there is any issues relating to the issues that threats to your health, you can go to the magistrate court under section 98. Therefore, most of the environmental issues are related to the health. Therefore, you can easily go to the magistrate court, and even you can obtain restraint enjoining orders from the district court, and even you can obtain writs under the 13th Amendment from the provincial high courts. But as time is restricted, and Vishwa is signaling me to stop, I am stopping here. Thank you, Vishwa and Dr. Mrs. Konas.
Thank you very much, sir. I've had long chats with you, sir, and I understand that 12 minutes certainly is not enough, and certainly 1 hour is not enough to go deep into these issues. But from some of the issues that have been discussed so far, what I feel is that it may all stem from a misconceived notion of what development is. But going forward, I think the way forward is sustainable development. Dr. Konasinghe, ma'am, is there are there any tools that the public can use for sustainable development?
Yes, now we have several concepts and principles in international law, international environmental law, which can be used in this discussion. One such principle is precautionary principle. It is widely used principle in environmental law in what that suggests taking precautionary actions at present to prevent future environmental damage. Sustainable development concept, on the other hand, suggests utilizing natural resources for the present generation's development goals without compromising the same of the future generation. So the combination of these two principles and concepts created a wonderful tool in environmental law, that is Environmental Impact Assessment Report, the famously called as Ieee. Now in Sri Lanka, I think everybody knows about this Ieee with many incidents took place recently. If I may remind few of those, Mount Lavinia Coastal Nourishment Project, and also Port City Project and Umaoy Project, what happened recently, that made everyone enthusiastic learning about Ieee. So in my opinion, it is a strategic legal approach to prevent environmental damages, especially as a consequence of major development projects.
Thank you very much, Madam. I'm happy to invite a pioneer in environmental activism in Sri Lanka, Mr. Ravi Algama, to elaborate further on this tool of sustainable development, the EIA.
Thank you. Thank you, Vishwa. And thank you, Dr. Kokila, for your initial comments on EIA. For our viewers, what is an EIA? What is an environmental impact assessment? It is a prophecy. Basically, it's a prophecy. It's a statement of predicted consequences, not by hazarding a guess, but by confirmed scientific data and reliable information. That constitutes an EIA. The EIA came into Sri Lanka's statute books for the first time in 1981, almost 40 years ago, as old as the organization which was mentioned by Vishwa, the Environmental Foundation. The definition in the Coast Conservation Act of 1981 says an environmental impact assessment is a written analysis of the predicted environmental consequences of a proposed developmental activity. It includes a description of the avoidable and unavoidable adverse effects of this activity, and even more so, a description of the alternatives to the activity which might be less harmful, and if those alternatives were not selected, what was the reason for not having selected those alternatives. So I will emphasize at this time that alternatives are at the heart of the EIA process. For instance, just as an example, take the Nurochole coal power plant. Why coal? Aren't there any alternatives? Is hydropower potential now fully, is it almost over now? What about renewable energy? What about waves? What about ocean thermal energy? What about everyone is talking about solar? Okay, solar is good, available, but not harnessable in a large scale. It's a capital intensive program which Sri Lanka is not able at this time to harness on a big scale. So all I'm saying is that alternatives must be addressed, less harmful alternatives, and if they were not addressed or brought in, why? So okay, now okay, so it's coal, no alternatives. Then where is it to be sited? Why Norachol? What about Trincomalee? What about Jaffna? What about Tangal or Gaul or even Colombo? So then there will be other considerations. There will be arguments. In one place, the sea is too shallow. You cannot bring the ships carrying coal inward. And therefore, the coal has to be unloaded onto barges so many miles away and then transported to the power plant, which, as you will guess, will always push the unit price of electricity up. So since that is the bottom line, then that is the justification for not taking those alternatives. So as I said, this concept came into Sri Lanka in 1981. It was reiterated in the National Environmental Act amendments. Actually, the National Environmental Act preceded the Coast Conservation Act in 1980, but still it had no teeth, or it had no enforcement provisions until it was amended by Act number 56 of 1988. And this brought in provisions of environmental impact assessment, which were there in a slightly more primitive way in the 1981 statute 7 years previously. Then again, as Mr. Jagat Gunawardena mentioned, the Fauna and Flora Protection Act, the Amendment Act, which amended an age-old 1938 ordinance, brought in provisions that any development within a mile of the boundary of a national reserve requires the permission from the Director of Wildlife Conservation, or Director General as he is now called. And then that approval or disapproval or rejection will come on the basis of an environmental impact assessment or an initial environmental examination, an IEE, which is also defined in the National Environmental Act, which is a lesser form of an EIA. We did not go too much into it at the moment, but where a project is thought not to have such serious consequences, there is provision to do a less stringent analysis called an IEE, Initial Environmental Examination. There are a few differences, like in the question of being open to the public for comments, where an EIA is mandatorily open to the public for 30 days for their comments. I will just mention in passing that there is the Northwestern province also has its own statute on environment, drafted, of course, by an NGO, the EFL at that time. And this statute has elaborate provisions of environmental impact assessment. So we have 4 statutes in all, 3 national and 1 provincial, which has provision for environmental impact assessment. Under Part 4C of the National Environmental Act, there are provisions, firstly, for that chapter deals with approval of projects. And there are provisions, firstly, for establishment or recognition of several agencies who are called project approving agencies. Now you will understand that the EIA is commissioned or is done by the person proposing the project. If someone is proposing, say, a golf course, it's the company that is encouraging or who's having this project, planning this, which gets the EIA done. It gets together with the experts, constitutes the panel to do the necessary scientific studies, and comes up with a. So it can be assumed that they would downplay the bad effects of the harmful effects of the project and exaggerate the beneficial effects. So that is why you need an independent body, which is called a prescribed agency, and the project approving agencies, which are basically so many ministries, and there are other Coast Conservation Department, the Central Environmental Authority, UDA, Geological Survey and Mines, and several other agencies. So then under prescribed projects, there are so many projects which are listed which need environmental impact assessment according to the magnitude. Just to give you a few examples in my limited time, say if it's roads, it will, any provincial or national highways over 10 kilometers in length have to go through an EIA process. If it's water supply, a capacity exceeding 500,000 cubic meters. If it's extraction of timber exceeding 5 hectares. Then if it's hotels, it will be over 99 rooms, or 40 hectares, exceeding 40 hectares, as the case may be. But there is also provision in this statute under the same part that all these projects listed under these different magnitudes, irrespective of their magnitude and irrespective of where they are situated, if they are in an environmentally sensitive area, they have to go with a EIA nevertheless. In other words, if it's an environmentally sensitive area, even a 2-roomed hotel will have to go through an environmental impact assessment. So the main thing to understand, it's a management tool. This has the capacity to identify harmful effects of a project at the very early stage so that you can address it without much expense at that time, rather than having to undo the damage later. For instance, as Dr. Kokila mentioned, we have the PPP, the polluter pays principle, and as Mr. Ravindranath Dabre mentioned, the precautionary, as she said, the precautionary principle. So these principles make it incumbent on the person causing the damage to actually come up with the solution to it. So it is very much less expensive at that stage. Then the most important thing I want to highlight finally is the public involvement in the decision-making process of the country. When thousands of people were extracted from Kothmale, from Digana, Peldenia, from various places and deposited in the dry zone with the promise of schools, hospitals, housing, and sort of a dry zone experience for them, as it were, from a place where even a seed thrown out of their window would have germinated the next day or the following day. So did those people have any say in the matter? They could have protested, they could have gone through their politicians, but there was no lawful way for them to have intervened in the decision-making process. Now, thanks to the EIA process, that is available to people for the first time in this country to have a say through their public comment period in the decision-making process. Thank you, Vishwa. I can see you looking at your watch. So I know my time is up. Any more clarifications perhaps in the question and answer time we might be able to do.
Thank you so much, sir, for that great description of the very valuable tool that is available to the viewers and the public of Sri Lanka when dealing with matters that concern the environment. Before we move on to the questions and answer session, and I can see that there are lots of questions that have been posed on the Zoom Q&A tab, I would like to invite the panelists to make a very brief closing remark before we move on to the Q&A session. Dr. Konasinghe, madam.
Yes, thank you, Vishwa. As of concluding remarks, I have 4 propositions for the 3 main organs of the government, and also that is executive, legislative, and the judiciary, and also for the people of this country who hold the sovereignty of the land of Sri Lanka. So very briefly, let me conclude my remarks. Number 1, for the executive, ensure systematic implementation of the existing legal framework on environmental protection. For the legislature, I would say ensure constitutional guarantee of environmental rights of the people. 3, for the judiciary, apply more creative and liberal interpretation in environmental matters on environmental provisions. Finally, for the citizens of this country, whenever needed, stand by your right to clean and healthy environment, and also respect for the rights of nature. You cannot survive without nature. You can't overrule nature. You can only live in harmony with it. So that is my brief comment.
Thank you very much, Madam. Mr. Gunawardena, your final remarks.
Thank you. My final remark is that everyone owes a duty and responsibility to protect the environment. Duty and responsibility that is enshrined also in Article 28 of the Constitution of the Republic of Sri Lanka. Therefore, my appeal is for everyone to assert their rights and do their bit to protect the environment as far as they are able to, from wherever they are in. On the other hand, we have to be assertive in protecting the environment. We don't have to be in the defensive in trying to protect the environment, saying that we are not against this or that we are not against this. Let the people who wants to modify or destroy the environment justify their cause by saying, we are not going to destroy the environment, we are not going to harm the environment. We don't have to be in the defensive. Let those people who want to destroy or modify or use the environment for other purposes may be in the defensive. So for the people, I have appeal, know your environmental rights, know your legal rights, know the subject, and please do intervene in order to protect this environment for the next generation and the future generations. As the topic very aptly describes, we are fastly losing time, we are fastly losing ground, we are fastly losing species of animals and plants. Some of them are endemic and unique to this country, and we have to act fast if we want to protect whatever is left for us to protect. Thank you.
Thank you very much, sir, for that dire warning. I hope our viewers and listeners take note of that warning. Mr. Rabindranath Davre, sir, your closing remarks.
Thank you. Actually, I would like to continue from where Mr. Jagat Gunawardena stopped. Actually, he requested all of us to act. Now, how to act? Normally, most of our lawyers, as the viewers and the participants are, I presume, as should be lawyers. When environmental issue arises in your location or in your neighborhood, or when there is an environmental issue with your client, you should not think that you have to go to the Supreme Court. Therefore, you are helpless. You can't solve this issue. You can't act to prevent that pollution or your environmental damage. You can act to resolve the problem faced by the human beings. Actually, there are a lot of avenues, even from your location. If you look at the Criminal Procedure Code, as I previously briefly mentioned, under Section 19, Section 98 said that any trade or occupation or keeping of any goods or merchandise should, by reason of its being injurious to the health or physical comfort of the community. Actually, these words we can interpret very broadly, and most of the 98% of the environmental issues can be brought into this definition, and we can get the police or the government authorities to file Section 98 cases. Even IGP, in IGP Circular 1696/95, IGP has instructed the police officers, as far as possible, file 98 cases when environmental complaints are received. Therefore, if the police is not taking cognizance of the complaints, at least you should file Section 98 private plaint, or even a private plaint is not required. Under Section 98, even a report is sufficient for the magistrate to issue a conditional order. And this is very useful because in other laws, the laws are there only to punish the offenders, but Section 98, actually you give the Section 98, the court can give the solution, court can give the issue the conditional order to resolve the environmental issue. That is what I can say within the 2 minutes allocated to me. Thank you.
Thank you very much, sir. Mr. Algama, over to you, sir.
Yes, for my doc statement. I would suggest many of you will see that there will be notices in newspapers sometimes in the Gazette, if you're in the you're used to perusing documents like that, of calling for public comments on EIAs. They will say there is a proposed project here at the Pradeshia Sabha in Beliatta, at the public library in Tangal. This is being made available for public comment. So if there is a lot of technical data, you should go with someone who understands, who can interpret that data for you, but don't lose that opportunity which has been got for the public with a lot of sacrifice by environmental activists. I have been involved in these struggles at that time, asking, we tried to get more time, but we had to settle for 30 days. There was a time when the head of state thought Sri Lanka is struggling in development only because there is a 30-day period for public comment, and she reduced it by executive action to 14 days, the president of the country. Fortunately, there was a minister of environment, I can even mention Mrs. Srimani Athuratmutali, who was extremely agitated by this decision and threatened to resign from the government on this issue. And therefore, since her party, I think it was called the Democratic United National Front or something like that, because it was important to the ruling coalition, quickly the 30 days period was restored. So I want to tell you, it has been the experience in our country. If there's a coal power plant in Mavalla or Kudavalla, the Buddhist priests will get involved in Thangalla and in down south, and they will start huge processions. If it's in Norachole, in Putlam, the Roman Catholic clergy will get involved. This concept, this practice of getting involved, if the problem is in your backyard, must stop in this country. We must think of Sri Lanka holistically. And if there's a problem in Jaffna, in Trincomalee, Batticaloa, or Colombo, or Gaul, or Matara, we must equally be able to react to these situations. And in the context of an EIA, we should be able to send in. It's not just a right that we have; it's a duty that we have to give our public comments on these developmental activities. Thank you.
Thank you very much, sir. Thank you very much, sir. We move on to the questions. We have a lot of questions that have been asked, so we are dealing with a very short window of time. The first question I would like to pose to Mr. Jagat Gulawardena, sir. There is the participant who is asking, what can we do in relation to the existing laws on air rifles? that are responsible for the murder of several species of wildlife, especially the critically endangered and endemic purple-faced leaf monkey?
The issue has to be tackled in two aspects. One is through the firearms ordinance, under which certain types of air rifles are banned. And first of all, we have to see whether that firearm is a banned type of air rifles or whether it's a permitted or licensed type of air rifles. The second aspect and the most vital aspect when it comes to the environmental law aspect is that the purple-faced leaf monkey is a protected species under Section 30, and it is an offense to injure or harm any such a species. And all the birds, except for the 5 species of birds which are not protected, are protected by the law or strictly protected by the law. And therefore, it's an offense to injure them or kill them. Therefore, a person who is using an air rifle or even a catapult to injure or maim or kill an animal which is protected can be taken to task, regardless of the weapon being a licensed weapon or not. But on the other hand, if the weapon is harmful to a human being, or it can cause injury or grievous injury to a human being, it can be banned, even if it is already not being banned. Similarly, the spear gun was banned some time ago under the Fisheries and Aquatic Resources Act, but under the Fauna and Flora Protection Ordinance, we don't have a provision to ban a particular equipment. But since an air rifle or an air gun is a firearm under the Firearms Ordinance, we can take that avenue to ban that kind of a gun, which can be injurious.
Thank you very much, sir. Mr. Ravi Agama, there is a question directed at you. Ms. Dhanush and Kanishag is asking whether an individual can file an action against an institution in the district court which has provided a faulty or inaccurate EIA which results in damage to that individual's property.
Definitely, you can. Of course, in the case of if it's a government department, then there will be provisions applicable to giving notice to the Attorney General under Section 461 of the Civil Procedure Code of a 1 month's notice of an action, annexing the draft plaint, and also you can ask for a declaration that the decision or the information given was wrong, and ask for damages as well. You can do that.
Thank you very much, sir. Ms. Davare, there is a question directed at you, by Sujiva Fernando, who is saying, now there is a new ministry for waste disposal under Honorable Nalaka Budahera. Now the duties have been split as waste collection and transportation to local authorities and waste treatment and disposal to the new ministry. How will the existing legal framework work under this situation?
Actually, the existing legal framework doesn't identify different ministries as such, but there are this particular waste national waste policy is formulated. It has to be approved by the cabinet. Once it is approved by the cabinet, it will be a subsidiary legislation, and it has to be adhered by all the government and the private stakeholders. And even the new ministry and the minister will have to abide by the existing laws, because there are no different laws formulated to be followed by different ministries, but existing laws which I have described in my description, early description, has to be followed by new ministries formulated according to the administrative purposes of feasibility of the government.
Thank you very much, sir. Dr. Konasinghe, there is a question to you, and that is the extent to which principles of sustainable development are applied in today's context. Can you comment on that, Doctor?
Sorry.
Ma'am.
I think the legal framework on sustainable development is very clearly defined in National Environmental Act and also Coastal Development Act and Fauna and Flora Protection Ordinance. The problem, I think, this person who is asking the question may raise a few other doubts on the implementation level. So there are certain issues that we have to deal with sustainable development concept with regard to Ieee or any other provision is at the implementation level. So that is why actually in concluding remarks I mentioned for the executive that to ensure systematic implementation of these laws and provisions, existing laws and provisions. So in my opinion that sustainable development concept is very well can very well implemented through tools such as Ieee and environmental protection license. So all of these tools are aimed to prevent future damages and protecting rights of the future generation. So I think in the present legal framework, existing framework in Sri Lanka, very clearly and precisely define sustainable development goals, but unfortunately at the implementation level there are certain problems that we have to deal with.
Thank you very much, Madam. I open this question to the panelists. Shamin Silva is asking, and he says that there is a vast amount of forest tract falling within the purview of the Forest Department, within the area of Umukkang and Hadoya, which is being destroyed for the purpose of corn cultivation by the villagers with the blessings of private companies. Is there anything being done about it by the Forest Department?
Maybe I will answer that question since it falls under the purview of forests and wildlife. The Hadahoya area can be in the eastern province in the Digamadula district or maybe in the Monragala district. I don't know which area he is referring to because it's a river basin or canal basin. But some of the lands are there which are declared under the Forest Conservation Ordinance as reserved forest or forest reserves, and the other land is other state forest or areas that are state land but not declared under any other legislation in this country. So if it is undeclared forest land, the Forest Department has a right and a duty to intervene under the provisions of Section 20 of the Forest Conservation Ordinance, where no one is allowed to clear or destroy any vegetation in other state forest, and also they cannot have any cultivation unless they have a permit to do so issued by either the Forest Department or by the Divisional Secretary. So there is a possibility that the Divisional Secretary or the government agent of the area would have issued a permit, so that has to be checked first of all if that land falls under the category of other state forests. But if it is forest reserves or reserved forests, definitely there cannot be anything and it will be per se illegal. So if it is other state forest, we have to make a clarification whether it has been given permission or whether it's an unpermitted activity. If it is an unpermitted activity, both the Forest Department and I should mention that not only the Forest Department, the Divisional Secretary can take legal action against the people who are making the cultivation under State Lands Recovery of Possession Act of 1979 and evict the people who are unlawful settlers in that area of land.
Mr. Gunawardana, there is another question that is directed at you, and that is a quick question. What is the current level of protection for white sandalwood under the Fauna and Flora Protection Ordinance, and how is it applicable to commercial sandalwood plantations in Sri Lanka?
Good question, because let me first answer the first part of the question. The white sandalwood or Suduhandun is Santanum album scientifically known. And it's a species that is listed under Schedule 8 under Section 42 of the Fauna and Flora Protection Ordinance, which is that it is a protected species of plant in Sri Lanka. And according to the provisions of Section 42, anyone can cultivate this plant. So having a cultivation is not an issue. But harvesting the plant for commercial gain is not a permitted activity, because under Section 42, it's prohibited to destroy or harm any plant that is deemed to be a protected plant. When people wanted to establish plantations of white sandalwood, we told them very clearly that they can establish plantations, but they can't harvest it. So I am not very much clear about what is meant by a commercial plantation. If they intend to harvest it, there is no provision in the law, the Fauna and Flora Protection Ordinance or any other enactment that permits the harvesting of white sandalwood for commercial gain. Again, I should refer to the long title of the Fauna and Flora Protection Ordinance, which specifically precludes the commercial and other misuse of the native fauna and flora of this country. Taken together with Section 42, it precludes the harvesting of white sandalwood from even a plantation. Thank you.
Thank you very much, sir. There is a question. I want to combine a few questions here and ask it. It relates to the EIA. And that is, there are people complaining that there are certain projects that, to their knowledge, are going ahead even without an EIA. And they want to know what can they do to stop such projects, or at least ensure that a proper EIA is done going forward. Mr. Agama, maybe you can shed some insight.
Yeah, if they do, if they can establish that this was a project which mandatorily had to go through EIA, but it has been observed in the breach, then the approval for that project can be contested by way of a writ in the Court of Appeal or in a provincial high court, as the case may be, and a person can ask in the public interest, a person or a body of persons, ideally a person who's affected by this unplanned or haphazard development, would be, due to our sometimes restricted rules of standing to sue adopted by our courts, he would stand a better chance, but certainly a legal action is possible.
Vishwa, even
Thank you.
Vishwa,
Yes,
even
sir.
if the public is affected by any such project, even they can go to the nearby magistrate court, can file a Section 98 public nuisance case also, and obtain conditional orders.
Absolutely, sir. In fact, there is a question directed at you by Chamila Veeratunga. She wants you to elaborate a bit more on Section 98 of the Criminal Procedure, the Code Act, and the remedies available under that section.
Yeah, actually, Section 98 of the Criminal Procedure Code deals with the public nuisance, and it is a very specific. Actually, we say it's a the procedure is actually quite different to the other procedures. Even by way of presenting a report, the magistrate can start the proceedings, right? If the magistrate has to obtain evidence, only he wishes to, or he or she wishes to take evidence. By looking at the report, if the report is very clear and if the report is combined, or if the necessary documents to show that there is a public nuisance is annexed to the report, and if there are affidavits annexed to the report that there is a public nuisance is taking place, the magistrate can then and there, without summoning the other party, can issue the conditional order. The conditional order is the most important thing in a case, because a case is filed by a litigant or the affected party to get some relief, not only to punish the offender. But most of the other statutes, they deal, those statutes deal with punishing the offender, not providing the remedy to the aggrieved party. But this particular specific section and the procedure, which is laid down under section 98, at the very first instance, remedies the affected parties. That is the most important thing. And even the public nuisance is very broadly defined. Even actually discomfort is occurred to the public, and if there is an imminent threat to the public, even if there is any imminent threat to the public health. Now, most of the environmental issues are connected to the public health. Now, for instance, if a industry is going on by causing excessive noise, right? That excessive noise might affect the public health. Even if an industry is emanating pollutants, maybe liquid pollutions, gaseous pollutants, right? That affects the public health. Most of the environmental issues are connected with the public health. Therefore, section 80 is a very important section and very easy to file. No need even to file a plaint, even a report is sufficient. Therefore, I am encouraging most of the young lawyers and the lawyers practicing at the local level to file 90s case as far as possible, even against the huge projects, you can obtain remedy.
Thank you very much, sir. Sir, there's another question to you by Ms. Shamanti Dunuvila. She's asking on Sri Lankan take on green taxes. Would green taxes be a solution to the issue on pollution in Sri Lanka to hold the polluter accountable?
That might be a solution, but who actually the most important issue in Sri Lanka is the relevant authorities are not properly monitoring whether after the issuance of the license by the relevant authorities, they are not properly monitoring the pollutants and the industrials. Therefore, it's very difficult. Even the green taxes are imposed. First of all, to obtain the taxes, we have to find out, or we have to prove that these people are polluting. To prove that, there should be a proper monitoring mechanism. The most important thing is to establish a proper monitoring mechanism by the authorities who issue license to these polluters and the industries.
Thank you very much, sir. Quickly, for the benefit of the law students, a question has been asked about what the best journals, books, or the sources of law that they should refer to be updated on environmental law. May I ask from each panelist where they would advise young lawyers who are concerned about the environment to focus their study on? Dr. Korasingham?
Yes, that's a very interesting question from my point of view as an environmental law academic. I think there are many books written on wide variety of areas. Particularly if you look at Burney and Boyle text on international law and the environment, and Philip Sands' book, those are the books that are recommended by the international law schools. So in Sri Lanka, there are few books written as handbooks on environmental law in various legal institutions. So those can be come in handy when it's about the Sri Lankan legal system. And if I say that to refer at the postgraduate level for research, I would recommend those two books as the main references. But in addition to that, there are various books written on environmental law in general, and also international law perspectives on environmental law. And also there is a very interesting book on international environmental law by Professor Sumudu Atapattu. Once she was a lecturer in the faculty, now she's in States in Wisconsin University. And that is also a very good reference for Sri Lankan students. In addition to that, I think all the cases, main cases, Chunakam Power Plant case, Bulankulama case, and all the other cases, Kandalama case, Navimana Berakam case, and then Port City, all the other Goldface Green case. So those case laws are also will be relevant for reference. So that will be a very brief answer, but if anyone wants any further information, I'm very happy to help, and you can reach my contacts.
Thank you very much, Madam. Mr. Gunawardena, any recommendations on books that young lawyers can read up on?
Yes. First of all, I would want to remind them that there was a environmental law journal called the Sri Lanka Environmental Law Reporter, which was published for some time and unfortunately which has now gone defunct, but they can always refer to the old cases, and some of the cases mentioned by Dr. Kokila are there in the Sri Lanka Environmental Law Journal. There are other publications periodically issued by the Environmental Foundation Limited, the Center for Environment Justice, the Central Environmental Authority, which also refers to the various enactments and the cases that they had been dealing with. In addition, there had been two publications by the Coast Conservation Department regarding the Coast Conservation and Coastal Resources Management Act. Although they are a bit old now, they too can be used for reference purposes. And as Dr. Kokila said, there are so many other publications which I suddenly can't recollect out of my memory, but which can be used for reference purposes by the students. And in addition, there are certain issues of the LST journal or the Law and Society Trust journal, which also had references to different environmental cases, which also could be a good reference source. And lastly, I should say, whenever they need help, I would be available and they can always contact me and get the details if there is any way that they want to do a reference. But for students, I would recommend another course of action or two other courses of action. First of all, when they see an environmental problem, either in the media or when they hear of an issue, please do refer to the law. And if they have to refer to a regulation, do refer to the regulation and make your own references. That will be one of the best ways for you to be proficient in environmental law or maybe in any other stream of law. And the second is, if you have any doubts, ask a person who is a senior and who is familiar with that aspect of the law. And on the second aspect, of course, I will be always willing to help. Thank you.
Thank you so much, sir. Mr. Dabare, what about your recommendation, sir?
Actually, Dr. Kokila and Mr. Jagat Gunawardena recommended a lot of things. Therefore, I have left very few things. Even Sinhala readers, there are some books written by Mr. Karunaratna Herath, the President Council. And there is another book written by Mr. Lalit Gamage. And in addition to the cases referred by Dr. Kokila, I would like to recommend all of you to go through the recent Chunnakam case, actually SCFR 141/2015, that actually gives a lot of very great insight about the recent development of the environmental law in Sri Lanka.
Thank you, sir. Mr. Agama, finally, what would you recommend to young?
I have actually nothing
Yes,
more
sir.
to add to what has already been said by the panel, except to make a slight correction. It was the South Asian Environmental Law Journal that was published, which has a number of cases, not only from Sri Lanka, but Bangladesh, Philippines, India, and a few other places as well.
Thank you very much, sirs. Unfortunately, we don't have any time left to continue with this very interesting discussion. I I once again thank the panelists for spending their very valuable time with us to enlighten the viewers about this very pressing issue and about the laws that govern this issue. And I hope that the time spent with us today has given you the courage to go on ahead and fight for what is important. I also like to thank once again the Bar Association for having organized a very needed seminar under this topic. And I thank you all for having participated on today in today's seminar. Thank you all. Thank you, sirs.